his own case and establish his entitlement to every relief claimed, he who assert must prove the burden imposed by section 131, 132, and 132 of the Evidence Act remains on the claimant throughout, except where the law shifts that burden. See Omisore and Aregbosola and Ogwahumu and Chiegboka. Citations are all provided. Furthermore, the court has consistently maintained that unchallenged evidence is not synonymous with automatic proof. Such evidence must still be credible, cogent, admissible, and sufficient to sustain the relief sought before judgment can be entered in favor of the party relying upon it. Accordingly, although the defendant has offered no evidence in rebuttal, this court remains under a duty to evaluate the claimant's pleadings, oral testimony, and documentary exhibits in order to determine whether they satisfactorily establish the claims before the court. Even minimum proof is enough. See Ogundipe versus Kwara State and Abi versus CBN. Citations are all provided. It is equally tried that in disputes arising from contracts of employment, the rights and obligations of the parties are principally governed by the terms voluntarily agreed upon by them. See NIIA versus Ayan Falu and Umera and NRC. The court neither rewrite the contract of the parties nor import into it terms which the parties themselves did not contemplate. Consequently, the court's primary duty in a case of this nature is to examine the contract of employment and determine whether the termination complained of was effected in accordance with its express provision with the preliminary observations. With these preliminary observations, I shall now proceed to consider the evidence placed before the court and determine whether the claimant has proved each of the relief sought. The law is firmly settled that where an employee alleges wrongful termination of his employment, three essential facts must be established before the court can grant relief in his favor. First, he must establish the existence of a contract of employment between him and the employer. Secondly, he must place before the court the terms and the conditions regulating that employment. Thirdly, he must demonstrate in what particular manner those terms were breached by the employer. I therefore concur with the claimant in NITEL and PLC and Aqua, Organ and Nigeria Liquid NLNG, and also Angel Speeding Dying Ltd versus Aja. And Okwebo versus Police. The rights of the employer and the employee are measured by agreement voluntarily entered into by them, and the court can only enforce but not rewrite the contract. See Babatunde and Bon and Manya versus Idris. Citations are all provided. The claimant tendered his contract of employment dated the 16th day of October 2023 as Exhibit 1. From the evidence before this court, there is no dispute that Exhibit C1 governed the employment relationship between the parties. Indeed, the defendant, having failed to file any defense, did not challenge either the authenticity or applicability of the document. The next question is whether the defendant complied with provisions of Exhibit 1 when he terminated the claimant's employment. The claimant's evidence, which remained uncontroverted, is that on the 15th day of April 2024, he attended the defendant's routine virtual daily stand-up meeting. At the conclusion of that meeting, he was formally informed by the defendant's CEO that his employment had been terminated with immediate effect. 3 days later, by email dated 8th of April 2024, he was instructed to hand over his duties and informed that his last day with the defendant would be 30th day of April 2024. The claimant further testified that Clause 19A of Exhibit C1 requires the defendant to give him 30 days written notice before terminating his employment, and further entitled him to 30 days compensation where the defendant initiated the termination. Learned counsel reproduced the relevant contractual clause in the final written address, and there is no contrary evidence before this court. The court has carefully considered the evidence. The oral notification of termination of 5th April 2024 cannot, by any stretch of imagination, satisfy a contractual requirement for 30 days written notice. Similarly, the email of 8 April 2024 directing the claimant to exit the company on the 30th day of April afforded him only about 22 days before his exit date. Even if the court were to regard that email as a notice of termination, it clearly falls short of the 30 days expressly stipulated by the parties in Exhibit C1. The law is elementary that where parties have agreed on a matter in which their contractual relationship may be brought to an end, neither party may unilaterally depart from those agreed terms. Compliance with contractual notice provisions is mandatory and not optional. Accordingly, I have no hesitation in holding that the defendant failed to comply with the express provision of Exhibit C1 regulating termination of the claimant's employment. I therefore find and hold that the termination of the claimant's employment was wrongful, not because the claimant lacked the power to terminate the employment, but because the termination was effected in breach of the procedure mutually agreed by the parties. Having found that the defendant failed to comply with the provisions of Exhibit C1 regulating the termination of the claimant's employment, I shall now consider each of the reliefs sought by the claimant to determine whether they have been established by credible evidence. The first relief seeks, and I quote, a declaration that by terminating the claimant's employment during the virtual meeting held on the 5th of April, without giving him notice of the manner prescribed in his contract of employment and refusing to pay contemporaneously with the termination of his employment, his salary for the month of April 2024, as well as his 30-day compensation package as provided by his contract of employment, the defendant committed a breach of the terms of the contract of employment dated 16th of October 2023. A declaration is an equitable remedy. It is never granted merely because it is unchallenged or because the defendant has admitted the claim by default. The claimant must succeed on the strength of the credible evidence. See Bello and Eweka and Dumes and Wakoba. Citations are all provided. From the evidence before the court, the claimant established that 1, there existed a valid contract of employment between the parties, which Exhibit C1, which he tendered in Exhibit C1. 2, the contract especially required 30 days written notice before termination. And 3, the defendant orally terminated the employment during a virtual meeting on the 5th of April 2024. And 4, the defendant subsequently sent an email requiring the claimant to exit employment on the 30th day of April 2024, thereby giving less than the agreed notice period. These facts remain uncontroverted. I therefore find that the defendant breached the express provisions of the contract of employment regulating termination. Accordingly, relief 1 succeeds and is hereby granted. The second relief seeks a declaration that the defendant action of terminating the claimant's employment without proper notice and refusing to pay the claimant his salary for April 2024 and his 30-day compensation package in violation of the express provisions of his contract of employment amounts to wrongful and unfair termination of the claimant's employment. The law distinguishes between an employer's right to terminate employment and the manner in which that right is exercised. Ordinarily, an employer reserves the right to terminate a contract of employment for good reasons, bad reasons, or indeed for no reason whatsoever, provided the termination is carried out strictly in accordance with the contract governing the relationship, COCO versus Federal Poly Bauchi. Also, a court cannot force a willing employee on an unwilling employer, CUBN and Chinyere Anagu versus Julius Berger. Citations are all provided. In the present case, there is no evidence before this court that the defendant lacked the power to terminate the claimant's employment. The claimant complains that the defendant exercised that right contrary to the procedure agreed upon by both parties. I have already found that the defendant failed to issue the requisite 30 days written notice prescribed by paragraph 19A of Exhibit C1, which states as follows: this agreement may be terminated by either party on the 30 days written notice to the other. If the employer shall terminate this agreement, the employee shall be entitled to compensation for 30 days. End of quotation. Consequently, the termination cannot be said to have been effected in accordance with the contract. Accordingly, I hold that the termination was wrongful because it violated the terms of Exhibit C1, Relief 2 hereby subsists. The third relief seeks an order of this court directing the defendant to pay the claimant the sum of 2 million naira being outstanding terminal benefits due to the claimant as salary for the month of April 2024 in the sum of 1 million naira, as well as 30 days compensation package equivalent to 1 month salary of 1 million naira following the termination of his employment at the defendant's instance on the 5th of April 2024. The evidence of the claimant is that although the defendant terminated his employment on the 5th of April 2024, he was instructed to continue working until the 30th day of April. And indeed, he performed his duties throughout the month before handing over all official responsibilities. He further testified that notwithstanding the work done during April 2024, the defendant failed to pay his salary for that month. This evidence has not been challenged. Indeed, Exhibit C3 itself, which communicated the exit date as 30th April 2024, corroborates the fact that the claimant remained in a defendant's employment until that date. An employee who has rendered service is entitled to remuneration for those services unless there exists a contractual basis for withholding payment. From all the pleadings and evidence, no such evidence exists before this court. I therefore hold that the claimant has proved his entitlement to his salary for April 2024 in the sum of 1 million naira. The next component relates to the 30-day compensation package. The claimant relies on clause 19A of Exhibit C1, which provides that where the employer terminates the contract, the employee must be entitled to compensation for 30 days. Claimant counsel argued that this contractual compensation is separate from the notice period and should be assessed as equivalent to a 1 month salary. There is no contrary interpretation before the court. The defendant elected not to appear to dispute either the existence of this clause or the claimant's interpretation of it. The court agrees that where parties expressly agree that an employee shall receive compensation for 30 days upon termination by the employer, effect must be given to that bargain. The claimant's unchallenged evidence is that his monthly salary was 1 million naira. Accordingly, the 30 days compensation package under Exhibit C1 is properly assessed at 1 million naira. The claimant is therefore entitled to recover salary for April 2024, 1 million naira, and the 30-day contractual compensation, another 1 million naira, making a total of 2 million naira. Relief 3 therefore succeeds in its entirety. The court shall now proceed to determine release 4 and 5 dealing with interest, solicitors' fees, cost, and the final consequential orders. The claimant's votes relief 6 and order directing the defendant to pay the claimant pre-judgment interest on the outstanding sum of 2 million naira at the rate of 20% per annum for intentionally and unlawfully withholding the said sum from the claimant from 30th April 2024 till judgment is delivered, and thereafter post-judgment interest on the same sum at the rate of 15% per annum from the date of judgment until the full sum is liquidated and paid to the claimant. It is necessary to point out that at the outset that in paragraph 5.21 of the claimant's final written address, claimant counsel expressly informed the court that the claimant was withdrawing and abandoning the claim for prejudgment interest. Where a relief claimed in a suit is abandoned or withdrawn, it automatically ceases to exist, and the court is without jurisdiction to grant it. See Ajao and Ademola, and also Nyako versus Asha. That aspect of the claim is therefore deemed abandoned and is accordingly struck out. The final issue is whether the claimant is entitled to post-judgment interest at 15% per annum on the total judgment sum. The law is settled that the award of post-judgment interest is a matter within the discretionary jurisdiction of the court. Such interest is not awarded as damages, but is intended to preserve the value of the judgment debt and encourage prompt compliance with the judgment of the court. With particular regards to this court, it shall not be less than 10%. See Order 47, Rule 7 of the NICS Civil Procedure Rules 2017. The court has also considered the submissions of learned counsel that the defendant has consistently refused to honor its contractual obligations, ignored the claimant's personal demands, and the subsequent solicitor's demand. He failed to defend this action and has thereby demonstrated an unwillingness to discharge its legal obligations voluntarily. In the circumstances, this is an appropriate case in which the court shall exercise its discretion in favor of awarding post-judgment interest. However, while the claimant urged the court to award interest at the rate of 15%, the discretion to determine the appropriate rate rests entirely with the court. Having regard to the facts of this case and the applicable rules of this court is of the considered opinion that an award of 10% per annum will adequately serve the ends of justice. Accordingly, I order that the judgment sum remains unpaid. After that, I order that if the judgment sum remains unpaid after 30 days from the date of this judgment, it shall thereafter attract interest at the rate of 10% per annum until the entire judgment that is fully liquidated. For the fifth relief, it seeks an order directing the defendant to pay the sum of 850,000 naira, being special damages representing professional legal fees incurred by the claimant in prosecuting this action. The claimant testified that he retained the services of his solicitors because the defendant refused to honor these contractual entitlements and paid professional fees in the sum of 850,000 naira. In proof, therefore, he tendered the receipt admitted as Exhibit C7. Counsel submitted that the said legal fees constitute special damages directly flowing from the defendant's breach of contract and urged the court to award same. I have carefully considered this submission. There is no doubt that the claimant incurred the good expenses in prosecuting this action. There is equally no doubt that Exhibit C7 evidences payment of professional fees. The question, however, is whether such expenditure is recoverable as damages against the defendant. The settled position of Nigerian law is that solicitors' fees incurred in prosecuting or defending civil proceedings are generally not recoverable as damages. Litigation expenses remain incidents of litigation unless there is a statutory provision or an express contractual agreement entitling a successful litigant to recover same. See Mwaji and Coastal Services, and also UBA and Virtual Agro. Citations are all provided. The rationale is obvious. If a solicitor's fee were routinely recoverable as damages, every successful litigant would automatically transfer the financial burden of engaging counsel to the unsuccessful party, thereby creating uncertainty in civil litigation. Consequently, Notwithstanding the production of Exhibit C7, I am unable to hold that the claimant has established a legal basis for recovering the sum of 850,000 as damages. Accordingly, Relief 5 fails and is hereby refused. Although the court has declined the claim for solicitor's fees, that does not preclude the court from awarding cost of the proceedings as cost follows event. C. Luna and COP River State and Bedamosi versus Alete. The award of cost is entirely discretionary and is intended to compensate a successful litigant that part of the expenses reasonably incurred in vindicating his legal rights. In the present case, the defendant ignored repeated demands for payment. He failed to respond to the claimant's correspondence. He failed to appear before this court despite service of the originating processes. He failed to file any defense and thereby compelled the claimant to pursue this litigation to judgment. The conduct of the defendant deserves judicial censure. In exercise of the discretion conferred upon this court and having regard to the circumstances of this case, award cost assessed at 500,000 in favor of the claimant against the defendant. Final orders. For all the reasons stated in this judgment, the claimant's case succeeds substantially, and it is hereby ordered as follows. 1. It is hereby declared that the defendant breached the contract of employment dated 16 October 2023 by terminating the claimant's employment without complying with the requirement of 30 days written notice prescribed therein. 2. It is hereby declared that the termination of the employment by the defendant was wrongful, having been carried out in breach of the terms and conditions regulating the employment relationship. And 3. The defendant shall pay to the claimant the sum of 2 million naira, being 1 million as salary for the month of April 2024 and 1 million as the contracted 30 days compensation payable upon termination by the defendant. 4. The claim for pre-judgment interest having been abandoned is hereby struck out. 5. The claim for 850,000 as solicitor's fees is refused. 6. The defendant shall pay costs assessed at 500,000 to the defendant. And 7. The monetary awards contained in this judgment shall be paid within 30 days from today, failing which they shall attract interest at the rate of 10% per annum until the entire judgment sum is fully paid. Judgment is hereby entered. This is the judgment of the court.